If you're building a tech startup and you say, we are raising VC, something weird often happens next. Not what's your traction, not what's your customer acquisition cost. It's cool. Are you a Delaware C-Corporation? And here is why that question matters. Delaware is not just a place you file paperwork. It's a legal operating system for companies. More than 2/3 of the Fortune 500 are incorporated there. So today at Icon.Partners, we unpack the real reason behind the Delaware phenomenon, the Court of Chancery, and why investors often refuse to fund startups that aren't Delaware C-Corporations.
This video is not tax advice, and it's not a general pitch for Delaware as the best jurisdiction in every scenario. It's a founder-focused explanation of two things: why Delaware's corporate law system is unusually predictable, especially because of the Court of Chancery, and why Delaware C-Corp became the default language of venture capital, legally, structurally, and operationally. You've probably heard the stat: 70% of Fortune 500 are in Delaware. The official Delaware phrasing is more than 2/3, and their published number sits in the 66 to 68% range depending on the year. So when people say 70%, they're basically rounding a real government-published fact. The important part is not the rounding, it's more like the network effect. Delaware is where corporate precedent, lawyers, investors, and deal templates have been pressure tested for decades. Here's the core. Delaware has a specialized court for corporate and internal affairs disputes, the Court of Chancery. Delaware's own courts describe it as the premier forum for disputes involving the internal affairs of the huge number of Delaware entities. What makes it special in practice comes down to two things. First, it's a court of equity with jurisdiction framed around matters and causes in equity, plus additional statutory jurisdiction. For founders, the translation is straightforward. It's built for corporate fights where the remedy is not just money later, but control and outcomes now. Things like injunctions, specific performance, board actions, and fiduciary duties. Second, that specialization has created a massive body of predictable case law. Delaware's corporate law portal makes clear that Chancery hears disputes involving the DGCL and business entity statutes, as well as disputes around corporate documents like charters, bylaws, and merger agreements. And predictability is what markets pay for. Founders often hear Delaware is investor-friendly and assume it means that Delaware always sides with investors. That's not the actual point. The real point is that everyone can model risk because the rules of the game are known. When your term sheet turns into a dispute, investors want to know what standard the judge will apply, what precedent says, and how fast they can get an answer. This is why Delaware's ecosystem stays dominant even when there's public debate about companies moving out through so-called de-exit. The system is a known quantity, and that's a feature, not a coincidence. Now, Layer 2, the Delaware General Corporation Law, the DGCL, is the core statute most venture lawyers build around. Delaware's own corporate site points to Title 8 as the corporate law backbone, including Chapter 1, the DGCL itself. Why this matters is that financing documents, governance mechanics, board duties, and stock issuance, the grammar of venture deals, are written assuming a Delaware corporation. That doesn't mean other states can't work, it means your deal has less friction when the entire legal stack is the one everybody already uses. Let's be direct. VC doesn't just want a company. VC wants a standardized equity machine. There are 4 practical reasons Delaware C-Corp became the default. The first is that venture deal templates are built for it. The NVCA model legal documents are widely used as an industry baseline for venture financings. These documents assume a stock corporation framework, preferred stock, protective provisions, board rights, and consents. The second is that C-Corp enables QSBS. If you want potential qualified small business stock treatment under IRC Section 1202, one of the key requirements is that the company is a C corporation. That requirement is right there in the statute text. QSBS is nuanced and fact-specific, and nothing is guaranteed, but the C Corp requirement is a foundational gate that can't be negotiated around. The third is that cap tables and equity incentives are cleaner. Options, RSUs, preferred rounds, secondary sales. These are mechanically simpler in a corporation with share classes, board approvals, and standard governance patterns. The fourth is a quieter reason that almost nobody puts in writing: fund-level constraints. Many VC funds have LPs like pension funds, endowments, and other institutions with tax constraints and policy limits. They often prefer structures that avoid pass-through complexity, unexpected tax filings, or operational headaches. A Delaware C-Corp is the most universally compatible wrapper for that ecosystem.
So what happens if you're an European Union startup incorporated somewhere else and you start talking to US investors? Often the answer is a Delaware flip. You create a Delaware parent C corporation and move the cap table under it. Investors want Delaware governance standards, deal docs their lawyers can run quickly, a known forum if things go wrong, and a cap table that matches their playbook. This is not because your country is bad, it's because VC is a speed and repeatability machine, and Delaware is the lowest friction default.
Delaware is not magic and it's not free. There are a few realities founders consistently underestimate. One is the annual Delaware franchise tax and reporting requirement. Another is the registered agent requirement, as you need a physical presence in the state even if you operate nowhere near it. A third is foreign qualification in the state where you actually operate, which means you may still pay fees in your home state or country on top of Delaware costs. And a fourth is the legal costs that accumulate if your structure gets complex. So Delaware can be overkill for bootstrapped lifestyle businesses, local businesses with no venture trajectory, or teams that are genuinely certain they'll never touch institutional capital. But if you're building for VC scale, Delaware is often less about choosing a state and more about speaking the language the market already uses.
If you are watching this channel, you already know our angle. We work with tech founders who need legal structures that survive fundraising, cross-border growth, and hard compliance conversations. If Delaware C Corporation is the right move, the real work is not the filing. It's structuring equity, governance, IP ownership, founder vesting, option pool logic, making the company readable for investors, especially if you are flipping from another country. If you want us to map the cleanest path to your situation, contact form in the description. A few words about the next episode. We will talk about the Delaware C-Corp setup founders actually use, authorized shares, par value, HS3B timing logic, and the common traps that make investors nervous. Thank you for staying here and have a good one.